Hello, hello, hello. It's Tony McGriffin coming to you from Chicago, as usual, where the Wi-Fi usually works. I don't know if it's working. Can you hear me? Can you hear me now? I don't see that anyone can hear me. Well, all right. Thank you, Alex. I'm back, baby. I'm back in Chicago. All right. So here we are. Zach sends me this. So shout out to Law Nerds Unite. Zach sends me a lead, but he's on a plane, so I don't even know. I don't even know if this is the clip he's looking for. It's over in Burton's room, and it's fun. I don't know if it's one he referred to, but it's fun. So let's give it a look. Also, Alyssa sent me an update that I haven't seen. Let's check it out. Okay, this is weird. It doesn't start with the actual clip that we're gonna watch, but you'll see it. So the first one is kind of not what we're here for, but the clip we are going to watch sort of merges into it. It's strange.
Okay, sir, I do have Mr. Barnes in front of the camera here.
All right, thank you.
You're welcome.
All right.
We're interested in the people that are top left right now. That's the one that gets more fun. But then we have this other hearing in between. It's short.
All right. Give me one moment. Okay, give me one moment, people.
I left Claude in Europe. It just there he is. I couldn't deal with him. There with his ridiculous jacket. Smells like Sauvage and sweat. Doing God knows what.
Okay, Mr. Molden.
Yes, sir.
Take the record.
Excuse me?
What is your name?
Keith Allen Molden Jr.
All right, this is case number 822-272917101. Peace and Michigan versus Keith Allen Molden. Appearance, please.
Good morning, Your Honor. Jasmine Martin, P86378, appearing on behalf of Mr. Molden Jr. Mr. Molden, please state your name for the record.
Keith Allen Molden Jr.
Thank you.
Wait for a reading, stand mute.
Yes, Your Honor.
The court wears a not guilty plea on behalf of your client. What is your bond request?
Your Honor, we're requesting a personal bond. Mr. Molden, he's 57 years old, a lifelong resident of Michigan, currently is working as a road mechanic full-time. This is a non-assaultive charge, Your Honor, and it was allegedly occurred back on 12/27 of 2022. It was entered April the 8th. Mr. Molden indicates that he's going to come to court And so respectfully, we're requesting a personal bond.
All right, Officer Dahl, what is your recommendation?
We have no objections to it personally, Your Honor.
$5,000 personal bond. Mr. Molden, no drugs
sir.
while this case is pending. You have 2 court dates, June 13th and June 20th, both in person, 9 a.m. in Canton, 35th District Court. Do you have any questions, sir, regarding your bond and or court dates?
No, sir, I do not.
Okay, step aside. You're going to interview Keats, correct?
Your Honor, I just have a question about his court date. You said it was June 13th for PCC and then June 20th?
Yes, ma'am.
Okay, thank you.
Yes, ma'am. Which way you want me to go? All right. Just stand right here, sir.
I want you back to your side.
All right, Ms. Martin, I'm going to put you back in the breakout room. You see all the people waiting for you, right?
Yes.
Okay. You get the hint.
Yep.
And there's more coming.
All right, here's where we slowly merge into it.
No.
Chicago.
We over here trying to say, look. And so okay. And then he goes, all right, go and get him.
Nothing like some Nordic babes.
You know, there's no rhyme or reason. There's why everybody just stand
I told you it was weird. I didn't know how to describe it. Gets weirder.
Super annoying, bro. Yep. Yeah, so that's why I got like, so you want to hear or you want to talk? Like,
Tennessee President?
Hi, Redford.
Yes, sir.
Is this Mr. Stedman?
Yes, sir. Siobhan Stedman.
Okay. All right, counsel, do you need a breakout room with your client?
No, Judge, we're all set. Thank you.
Okay, I'll be with you momentarily. I've got some other matters to handle, and I'll be with you momentarily. Thank you for your patience, counsel.
Thank you, Judge.
Okay.
They told me we not locked up. We can't lock up.
No.
They didn't have you do the swear to open the phone. No. It's not even my gun.
Hey, listen, dude. I've told you like 5. This isn't gonna change. I don't want to talk about the case. I don't want to hear about I don't have a gun or something done. Now's not the time. It's not gonna change anything.
Well, it wasn't.
I don't want to hear about it. I don't believe anything you say.
Okay, you don't have to.
All right. Well, then just shut up.
Still have a right to talk.
Not right now. You don't.
Yeah, I do.
No.
That's crazy. First, you're not gonna believe me.
Somewhere a little more comfortable already. And then just too quick. All right. Good for 2 seconds. Yep. All right. Let's go down this way. Go straight down.
If I was white, you would believe me, huh?
I was like that.
That's how you acting.
Okay. Good for you, buddy.
Cause you see I didn't have a gun. Right, he grabbed my arm. He threatened me that he had a knife, wherever. So if I'm reaching, I'm reaching for a gun. Put down gun. How would I not be able to show some like where to see?
I can't read Dawson's lawyer in the street.
So it's okay for someone to put their hands on me in the video. He grabbed my fucking wrist.
Guy, you're gonna have your day in court. And this ain't it today. So save it for court.
I was just thinking, like, with Jay would have never called, I would have never even known the one again. I mean, they called me.
Hey, sorry.
Yeah, how's it going?
How's it going? What does it just say right here? It says firearm times 2.
Yeah, that's what.
I have 1 firearm.
There's something going with you.
Hey, Mr. Stedman, please don't say anything. Please don't say anything at all.
Okay. I can't put my carry my clothes with me?
No, your clothes are evidence.
My
We're
clothes
keeping
already getting charged with it.
Yeah, they're evidence. We're keeping them. That's what you're gonna wear.
So just my phone and everything else, just the
Whatever's in your property lock, we'll go with you.
So I'm trying to show you what I did there. Basically, you know, started the TV and then go to that person. But what was fucking me up is the type in the number you have to hit.
Yeah, stop talking about your case, please.
That's not my clothes, because I'm also in charge of it.
We'll do all this
After trial. I guess, you know,
We're taking it to trial. So I'm not, I didn't put no gun on. Never told him I had a gun. Never. From my phone. I got a white collar today.
No.
Fucking chest.
yeah, I mean, I take it. Yeah, you know, I mean, so probably,
This guy, I mean, he just keeps going. The cop doesn't believe you, and it doesn't matter if he did.
Okay. Radford, Mr. Stedman, before we can proceed, can you have the officer come back? You Officer Eddings?
Yes, sir.
Okay, let's do the swear to, and then we can proceed with the arraignment. Okay. Officer Stedman, Mr. Stedman, Mr. Officer Reddings, it is Sunday, June 1st, 10:50 a.m. Magistrate William Burton, conduct the proper cause here in the matter of people of Siobhan Stedman. He's charged with count 1, assault with intent to do great bodily harm less than murder by strangulation, count 2, felonious assault, count 3 and 4, weapons from the firearm. Excuse me. Voice broken. All right, Officer Eddings, state your name for the record, please.
Ryan Eddings.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to give be the truth?
I do.
Detroit's rolling with the QD attorneys on Saturday. I'm impressed.
And you testify from your own report, correct?
Correct.
All right, proceed with your testimony, please.
Redford Township Police was dispatched to 19214 Wakeden for a shooting at 20:47 hours. Officer Wilson arrived on scene and spoke with the victim, Bryce Herdeman. Bryce stated that he was shot in the leg by his neighbor, Siobhan Stedman. Bryce stated that he saw Siobhan walking down the street, so he decided to confront him about a previous incident. Bryce further advised that they started arguing, which then turned physical. Bryce stated during the fight, Siobhan pulled out a handgun from his waistband and shot him in the leg. While on scene, Officer Wilson also spoke with Sarah Stedman, Siobhan's wife. Sarah stated that she and Siobhan were walking southbound on the west side of the street. Sarah stated that they were walking to her friend's house located at 19177 Wakeden. Sarah stated while they were walking on the opposite side of the street, Bryce started yelling and cursing at them. Sarah stated Bryce got off his front porch and approached Siobhan from across the street. Sarah stated Bryce got into Siobhan's face and he asked him to back up several times. Sarah stated while they were arguing, Bryce swung at Siobhan's face and missed. Sarah stated Siobhan and Bryce started fighting in the middle of the street. Sarah stated Siobhan was backing up, attempted to defuse the situation, but Bryce continued to follow Siobhan. Sarah stated Siobhan pulled his handgun out to get Bryce from trying to attack him. Sarah stated Bryce tried to attack Siobhan again and he shot him in the leg. Sarah stated Bryce walked to the corner and then followed them to their friend's house at 19177 Wakeden. Sarah stated they went inside the location to get away from Bryce, but he continued to knock on the door and attempted to gain access into the location. Sarah stated after a few minutes, Bryce left and went home. Officer Slamba made contact with Siobhan Stedman at his listed address as he was standing outside. Siobhan informed Officer Slamba that his firearm was on the front porch. Officer Slamba then placed Siobhan under arrest, secured the firearm, and turned it over to Officer Biaco. Siobhan also provided Officer Slamba his valid Michigan CPL license on scene. Officer Biaco removed the magazine from the handgun, ejected a live 9mm round from the chamber. The magazine contained 15 live rounds of ammunition, not including the round he ejected from the chamber. Altogether, including the round ejected from the chamber, there were 5 9mm rounds and 11 9mm hollow point rounds. The magazine was a 17-round magazine. Officer Biaco later packaged the listed firearm, magazine, ammunition, and holster, placed into an evidence locker at Redford. Officer Biaco transported Siobhan to the Redford Police Jail.
Okay, all right, court satisfied, probable cause has been established. All right, ready for the arraignment, counsel?
Ready, Judge.
Okay. Mr. Stedman, can you stand up, face the camera? State your name for the record, please.
Siobhan Stedman.
All right, this is case number 8225712351001. Peace of Michigan versus Siobhan Stedman. Appearance, counsel.
Good morning, Your Honor. Purna Krishnamurthy, P82448, appearing via Zoom on behalf of my client, Mr. Siobhan Stedman, who also appears via Zoom and consents to this proceeding being via Zoom. Mr. Stedman, would you please state your name one more time for the record?
Siobhan Stedman.
Judge, today is the date and time set for an arraignment on this matter. At this time, we would waive a formal reading of the information and stand mute.
All right.
And I would like to address bond when prepared.
Okay, give me one moment. All right, the court will enter a not guilty plea on behalf of Mr. Stedman. Give me one moment. All right, Miss Martin. Okay, I am in the middle of an arraignment with retained counsel in Dearborn. I'm going to put you in the waiting room with Dearborn Heights, okay?
Okay.
On this case. So sorry.
All right, Canton, Officer Dahl.
Yes, sir.
I will call you in a few minutes to deal with the probable cause for Keats, okay?
All righty. Sounds good. Thank you.
All right. Oh, you're there. We can do it. Just stay there. Let me finish this. I'll get to you next. Okay. All right. Thank everybody for their patience with multitasking here. I'm not very good at it. I'm just doing my best. All right. Counsel, let me guess what you're going to say. Let me guess. You're going to say it was a self-defense, at least arguably, and you want a personal bond.
Judge, I am going to say that in addition to what I would like to add to the court is that Mr. Stedman has absolutely zero prior history, Judge. He is a father who is married with 4 minor children. And to add to the record, it was Mr. Stedman and his wife that actually called the police, Judge. They have retained private counsel on this matter. Mr. Stedman has every intention on following through with this case through its very entirety. I have been in constant contact with his wife since yesterday morning when I first got retained on this matter. And I went and even saw Mr. Stedman yesterday as soon as I was retained on this matter. I've had an opportunity to speak with him. He and his wife take this incident incredibly seriously, Judge. And he would absolutely not pose a flight risk. I don't believe he would pose any threat to the community also because this is a one-off thing for him. He's 34 years old, has never, ever been in trouble before, Judge. And I'm willing to guarantee that once this case is wrapped up and over with, no criminal court will ever see Mr. Stedman again. He's a very responsible, gainfully employed young man.
All right, thank you. Officer Eddings, do you have any comments, Mr. Bond?
No, Your Honor.
Okay. Counsel, I would tend to agree with you. It seems like, although he doesn't appear to have any weapons, that the complaining witness initiated this verbal confrontation as a carry-on from a prior incident. So an argument could be made, a plausible argument could be made that he instigated this and things escalated. And an argument that for trial fact to determine at a later date, an argument could be made whether your client shot him in the leg in self-defense. That's not to be determined now. The fact that he is a CPL holder to go to your credit, counsel, in terms of that he is he has no criminal history, and by the alleged facts, he's minding his own business until confronted by the complaining witness. So I believe he deserves a personal bond of $20,000.
Thank you, Judge.
Only requirement we're going to have is while his case is pending, he's not to possess any handguns, firearms, or other dangerous weapons.
Thank you.
Probable cause would be June 10th, 9 a.m. Preliminary examination June 17th and 17th District Court in Redford. Is there anything else you want to put on the council put on the council record? Put on the record, council. Verbally dyslexic.
That's fine. Judge, if I could just have that first date one more time, Judge. Was that June 10th, you said?
Yes, ma'am.
Okay. Yeah. No, Judge, we thank you so much for your time. Thank you so much.
Thank you, counsel. All right. Is that it for Redford?
Yes, sir.
All right. Have a good day. Thank you, counsel.
Oh my God, the world's gone mad. I almost agree with you, Greg. Well, I potentially agree with you. I'm saying I'll tell you what's compelling about it for me, for this guy. No prior history, and he's not young. So this guy doesn't have any criminal contact. And he's got a concealed carry permit, which means you have to do a background check. So he really doesn't have a criminal history. And this guy isn't doing anything. And there's indications that he didn't start this. Now, you have to get into the facts or whatever, and today's not the day. And trying to convince the cop of it. prior to the hearing with a hot mic, it wasn't a good idea. But I agree that potentially there really is a good defense here, and I think the judge went the right way with this. Or maybe there isn't. Maybe he's just. Maybe he's, there's a little verbal going back and forth, and he pulls a gun for no good reason. There's really no self-defense, and there's whatever. These are facts that need to be straightened out in front of a court, and that's where we are. All right, so I've got another one here. Alyssa sent me. This is a follow-up to a guy I did before. I haven't seen it. But I always like to do follow-ups because people like to know what happened to people. This guy, Mr. Pritchett, I think I did his whole trial. I can't remember. I haven't seen it, so let's take a look and see what's going on here.
All right. Good morning, Ms. Rivers. Are you able to hear us?
Yes, I am. Good morning.
Good morning. So let's first please have a quick conversation with Mr. Pritchett, and I'd like to have that on the record. So that's the case of 20 SC 176922. Mr. Pritchett went to trial a while ago, and there was a motion for new trial, timely filed. And Mr. Pritchett, good morning. Are you able to unmute there?
Yes.
Great. Good morning.
Once Judge McBurney admitted in open court that he went to the Renaissance Fair with his son, and I can't get it out of my head.
And let me get you right there. Added to this conversation this morning because we needed to confirm with you your plans for representation, whether for your motion for new trial, you were going to represent yourself, if you or your family would be hiring someone, or if Mr. Hewitt, who is on the call here, would need to be called upon to line up appointed appellate representation.
Does he get into the spirit and demand faster service from the wenches? I don't think he has the stones for it, but I do believe he thinks it and holds it back.
On my end, I am still currently confirming just private representation. Now, I did speak with the public defender office briefly a minute ago, as far as just letting them, maybe at this point, help with the process to the extent that is necessary and what is needed. But I know ultimately the ball is still really in as far as moving forward, it's still in the court's hand because we at this point, I'm not aware of any transcript that has been produced regarding the trial. And I know that is needed to proceed forward with or without an attorney. Of course, for the new trial. Is that not correct?
So certainly a transcript is necessary, and you, if you're representing yourself or your lawyer, is 100% entitled to it. And the ball doesn't really get rolling until there's a transcript. And so I guess in one respect, we can wait until the transcript's done and then reconnect with you and have you decide. It's just helpful for Mr. Hewitt's team if they know that they need to line someone up. There aren't a whole bunch of attorneys statewide who focus on appellate practice like this. So you don't need to commit right now. It sounds like maybe that's still a little bit in flux. I'm calling your case up right now just to make sure the transcript didn't sneak up on us.
It did not, Your Honor.
Okay. Mr. Armstrong's checked, and the last I've seen is there's an amended notice of appeal letter from you Mr. Pritchett. There was one in April and another in May. So we are in this moment of pause. Ms. Rivers needs time to get the transcript done. But just typically what happens is we find out before then, all right, this is the lawyer for Mr. Pritchett. Here's who's representing the state. And we talk a little bit about scheduling. But that's more preparatory. You're right. Nothing can happen until that transcript's done, so that either you, if you're representing yourself, or a lawyer can pour over it to say, hey, here's where the judge made a mistake. Here's where whatever happened. So why don't you tell me right now which way you're leaning, and then we'll find out from Ms. Rivers what she forecasts for completing the transcript. I don't know where this falls in her list of cases that she's working on.
We know which way the victim leaned. I'll tell you that much.
I like I said, just me confirming just the private counsel that I have and my family has been in contact with. Of course, nobody has entered any appearance on the case as of yet. But again, that is still being confirmed. What I will do, I think at this point, just thinking about the conversation that I had with the public defender office, I will fill out the necessary forms. I think for their procedure as far as retaining counsel, there is some type of forms or questionnaire that they needed me to do. Just ultimately, if I was to lead in their direction, that needed to be complete to ultimately move forward. Just I guess for them to be on proper standby and not just lingering. I guess I can fill those forms out for their offices. Ultimately, if that is the route I will take, it will be ready,
proper standby,
at least to be taken. But at this point, nothing has been confirmed.
Okay, I think I follow all that.
Your Honor, may I mention something just because it's a possible snag and I want to make sure? I assume it's something that in this division of the court is not an issue. But because he represented himself at trial, I wanted to point out that applying for public defender assistance is good for establishing indigency, because that is what Georgia law has as the marker that establishes indigency is the public defender's office. And both the oral request for a transcript to the court reporter, but also
this chat will succeed in instituting conjugation camp somewhere. I guarantee it.
So how the transcript gets paid for is determined by indigency. And so if he files the indigency form and that goes into the record, that directs the court reporter to file it regardless of whether they're paid for it by other means.
Got it. Okay. That's a helpful piece of advice. So Mr. Pritchett, that's yet another reason for you to fill out that paperwork that would document, assuming it's accurate, that you qualify for appointed representation. The transcript will be completed. That's not what Mr. Armstrong was saying, but the question of how it gets paid for, if it has to be paid for, is driven in part by your financial means. If it turns out that you've got $100,000 on your books at Wheeler, then you're either hiring a lawyer who would be paying for that transcript, or you're representing yourself and you're paying for the transcript. But we aren't in that situation right now. Let me ask Ms. Rivers, who I know is writing things down, if she could give us a rough forecast of when she thinks the transcript in this case will be done.
Mr. Pritchett's case is actually next up to transcription after this.
I'm sorry, I couldn't quite hear that.
Can you hear me?
Yes.
Yes, Mr. Pritchett's case is next up to be transcribed after Sanders and Pittman, and I forecast that to be around August to be complete with both cases.
Okay, then why don't we do this, and then I want to hear from you, Mr. Hewitt, because we'll limit the number of times you need to plug in like this. It seems like if we got Mr. Pritchett and you, Mr. Hewitt, back on, and Mr. Armstrong or one of his colleagues in August, and Ms. Rivers and I work together, so I'll be checking in with her. But if it looks like that transcript is wrapping up then we ought to get everyone together again. And that will truly be the crossroads for Mr. Pritchett, because he'll have more time to work through with his family, whether they're retaining someone, or he will have completed the paperwork to get GPDC in the mix. And then he can let me know which of those three options, assuming he qualifies for GPDC representation, which are the routes he's going to pursue. That will be an actionable clock will be ticking by then. There isn't any.
The truth is, I just got done rolling through Europe. The truth is, every place else is exactly like the United States in this sense. The entire rest of the world, in my estimation, is absolutely awesome and completely screwed up, just as bad as us. We just show it more proudly. But there's an ounce of difference between here and the rest of the world. That's all I'm telling you.
Anything we could do right now because there's no transcript, but by August there ought to be one, and so it'll be a little more pressing for Mr. Pritchett to say, "Hey, here's what I want to do." Mr. Hewitt, anything you want to add, or does that work for you?
That works for me. I just add just so Mr. Pritchett understands what I'm doing here. I'm not his lawyer. I'm the statewide supervisor of the appellate division, and so I'm just sort of hovering over this case. You know, if we do need to appoint somebody, then I'll get that. I'll make that happen. And but if he wants to go pro se, that's fine too. Or if he doesn't qualify, that's fine too. But
Right.
I'm just sort of here to try to facilitate things. And I sometimes when I do these, the defendant thinks I'm their lawyer, but I'm not. Okay.
Nope. I appreciate you flagging that. I think Mr. Pritchett understood that you're in that supervisory capacity, and I appreciate him pointing out, hey, without a transcript, it's sort of moot right now. So I think that's where we are. Mr. Pritchett, anything you want to add? I had muted you because there was some background noise. You got to unmute.
Okay. There is one concern I do want to address.
Iceland is a good case in point. You are correct. It's insane. The sun never set when I was there. The air is super clean, and it's cold, and there's freaking lava everywhere. Nothing makes sense. Nothing. But they are friendly people, and it's an orderly society they got rolling up there. I don't know how. It is an alternate universe. You feel like you're on a different planet. A cool, interesting planet, but a different planet. That's the truth.
And that is regarding your response to the motion and the rest of the judgment that I filed. And honestly, Mr. McBurney, it does seem odd because the response to it was just pointing out my untimeliness for the motion that was filed, rather than discussing the issue at hand. And honestly, the timeliness was impossible. And it don't seem how it was constitutional. It does seem like it violated multiple of my rights because the judgment was entered May 2nd. The last date that I had to file that motion was May 6th. That was 4 days after you attempted to sentence me to football numbers. So it just, I don't see how it was just constitutional as far as you ruling in the direction that you did on the motion, honestly, sir. And again, like I said, the main issue wasn't at hand. You're trying to hold me to a standard as far as the timeliness and filing that I don't believe that even the court are holding the district attorney to, because the main issue at hand was, okay, well, is there, a record reflecting the return of the indictment in court? Heil stood up in a hearing. There is a record of this. I have the exact timestamp on one of the videos that you have on your YouTube channel of Mr. Heil stating specifically that there is no minutes. Minutes do not exist of the return of the indictment being returned in open court. That's not even how the process worked. And it really was a clear statement that was against the laws and procedures regarding that process. And so again, the issue at hand wasn't addressed, and I feel like I was being held to a standard as far as filing that I was just I couldn't do it honestly. So. And so I kind of can there be some type of it needs to be some type of reconsideration that I'm just kind of asking for as far as that motion is concerning.
So two things. One, that may be something that you or your appellate lawyer chooses to bring up when when an amended motion for new trial is filed. But number two, I note in the record, you have already filed a notice of appeal of my order. So that's out of my hands. You have appealed it. You'll pursue that appeal, and we'll see where that goes. But I don't have jurisdiction over that order now because you have challenged it, and you will navigate the Court of Appeals channels consistent with that notice of appeal that you filed. So you, as I said, may end up weaving it into the amended motion for new trial. Can't do that till we get our transcript in August. But before then, you'll be able to continue to work on that appeal that you filed. Anything else, Mr. Pritchett, before we get Mr. Ponder into your seat?
No, not at this point. Kind of call me off guard there, but I think that's on my end. I think that is it.
Okay, well, we will get you back onto Zoom in August at some point to see how we're doing with the transcript and to get a more final answer from you about representation. Mr. Hewitt, appreciate you joining us. You're welcome to stay for the Ponder one, but he's got a lawyer. His lawyer's sitting here in court, and we're going to pivot to that now.
I think I have plenty to do today. I appreciate the invitation, and like I say, if y'all have any problems, you can have Ms. Hansberry contact me on any of these appellate cases. I'm glad to straighten things out. That's what I do all day. Okay.
It is, and we appreciate your help. Thank you, sir.
Can I be excused, Your Honor?
Yes.
Okay, thank you. Mr. Pritchett, do you have something you want to say to me, or?
Mr. McBurney, can you just give me just a brief summary? Okay, after me filing the amended to your motion, what could I expect next as far as that process?
So you have appealed the order that I entered that dismissed.
This is the guy that just condescended to the judge about how the law works and refuses to get an attorney. Literally in the last 2 minutes. Now begging for what the hell just happened.
Your motion in arrest of judgment. So you see what else is in the docket. You had your notice of appeal. The clerk's office has sent to you some information. It's a checklist that you're supposed to complete. They most recently sent a letter in May to you, and you'll work through that. That's what you need to do to ensure that the record that's relevant to the motion in arrest of judgment gets to the Court of Appeals.
And that's the problem. How do I get that how do I get the record? I mean, how do I get that record?
So the clerk's office transmits the record. You don't have to go around doing anything, but they sent you a checklist, and they highlighted a couple things in that checklist that they're saying you did not include. And so you'll need to interact with them, not with me, about that. So you should be looking for that letter if you didn't receive it, although it was sent by certified mail, and it looks like, so it should be there by now.
All right. Appreciate it.
You bet. All right. If you could get Mr. Ponder, please.
Thank you, Your Honor.
Thank you, Mr. Hewitt.
Well, you mess with this guy, and now you got to suffer. I love it. I've got an update. I'll have to hunt down. I've got to have a playlist for that because I did the whole damn trial. I did the whole damn Charo. All right. Those are kind of fun. A guy pulls a gun, allegedly, out of his waistband and shoots another dude. And I'm not sure he wasn't justified. I'm not sure he was, but I'm not sure he wasn't. And then we got a nice little update on our SovCit, who busted he busted up a party of recreational chemists and show tune enthusiasts. He got convicted hard on everything, as well he should. It was disgusting. And right now, he still can't make up his mind if he wants to proceed on his own. Oh, sometimes it's too easy. Thank y'all for coming out. I appreciate it. I will see you all soon.